Today I'm talking about non-compete agreements in an employment relationship and whether they're really enforceable or not. I often meet with individuals that come to my office and sometimes they have a lengthy employment agreement that has a non-compete clause or a restrictive covenant saying that they can't go work for another employer within a certain period of time or a certain distance or within the same industry. And they often ask me, how does this work? And I've been looking at these non-compete agreements for decades now and have had the opportunity to litigate over some of them in court. And so I've noticed a pattern develop over the decades on basically how these are handled. First of all, if an employee is contemplating leaving their employment and they do have a non-compete, then the first step may be to ask the employer and say, I'm thinking of leaving, will you give me a release from the non-compete agreement? What does that mean? It means getting something in writing from the employer that says, yeah, sure, we're not going to enforce that. It could even be by email. You can email the employer and ask, and the employer could email you back and say, we're not going to enforce it, don't worry about it, and you could feel comfortable in getting a new job. Now, does that mean they won't enforce it after they promised they wouldn't? Not necessarily. But it certainly gives you some confidence to leave, and a court might not be willing to enforce the non-compete if the employer gave you their blessing to leave the company. Other issues that come up, what if you don't ask the employer because you know they'll say no, or they already have said no, and then you leave the company, and then you go to work for a competitor or otherwise too close or whatever the issue may be. So you go to work for that new employer, many times the matter arises with your former employer sending a letter to you and to the new company telling you to cease and desist, that you can't be working there and the new company is going to be sued, and they're making all these types of threats. The best thing to do if you get a letter like that is to respond. And the response could come from the company on your behalf, or perhaps you respond and the company responds separately. But if you don't respond, then there's really a good chance that they might file a lawsuit to try to enjoin you or get an injunction preventing you from continuing to work for that new employer. And courts are quite open-minded to giving those injunctions. So it really happens that courts will issue, oftentimes, but not always, will issue an injunction preventing you from being able to work at that new place of employment. Oftentimes I'll recommend to a person in the situation, maybe ask the employer in advance, if I go to work for your company, I need you to agree to pay for the defense costs in defending me if I get sued. So if you're in a negotiating position, that's certainly something that's important for you to ask for. And if there is an injunction, then that would prevent you from working for the employer. So it's really important, and I recommend that a person under a non-compete agreement, before they leave, go talk to a lawyer about the options that are available in getting out of the non-compete, in defending against the non-compete, in revealing to a potential employer whether you have a non-compete. Go visit with your own attorney who's got experience in dealing with non-compete issues, so they can give you proper advice under the particular facts of your job, your non-compete agreement, and the job that you're looking to get.